Hi, welcome to My Court Coach. I'm Jalen and I'm going to be your instructor as we navigate through Form DV-116, Order on Request to Continue Hearing. This form should be prepared before your Domestic Violence Restraining Order hearing because then the court will just need to check off a few boxes and sign off on their signature. If they in fact grant you your request to continue the hearing, or if they deny your request to continue the hearing. So you would need to just fill out the protected party's name, which could be you or the person that's requesting the restraining order, and then the restrained party is the alleged abuser. So it says the court will complete the rest of this form. And they will complete the rest of this form because you don't know whether your restraining order request to continue the hearing is going to get denied or granted. So they will check off this box or check off this box. And if they do check off this box, then there's more information that would need to be completed for sections 4 through 8. And the court right here will give you your new court date where you and the other party must return. And so if it says there's no temporary restraining order in this case until the next court date because, and it could be because your restraining order wasn't granted previously, or the court is going to cancel the previous granted restraining order. This is going to be very rare that the court does that unless you went ahead and requested that the court cancels the previously granted restraining order, but yet provides a new court date. That could be because this new court date could be about the child custody and visitation issue, for example. So if there's additional issues that the court does want to address, then the court can address that at the next hearing. However, we will say though that when the court does cancel a restraining order, then the restraining order case essentially goes away. It is dismissed. So in order for you to have the other pending issues on calendar, you would need to check off those boxes about custody and visitation in order for those orders to hold. So the next thing is the temporary restraining order is in full force and effect because the court's going to extend the previously granted restraining order. And this is where you would want to write in the date of when your first restraining order was granted. And then if it says, if there's no expiration date listed on your restraining order, at the end of the court date listed in 3B. So essentially that's going to be at midnight, and that's when your restraining order is going to expire if there's no time frame. But the court has to write in the date as to when the restraining order expires. The court changes the TRO previously granted and signs a new restraining order. So they're going to amend the restraining order. Or C, they're going to do something else. Maybe they'll partially deny, partially grant some parts of your restraining order, or just order something new as part of your restraining order. So warning and notice to the restrained party. So 4B is checked. A domestic violence restraining order has been issued against you, and you must follow the orders until they expire. So 4B, this is where the court has granted the restraining order again, and it has a new expiration date. So the reason that the court date is rescheduled, this is going to match your DV-115 form, your request for a new hearing. And there has to be good cause. So the court is going to reschedule the hearing because of good cause, and it could be that the other party just has not been served. The abuser, the aggressor, the alleged abuser has not been served by the protected party. Or there could be, another reason that both parties agreed to this new rescheduling, or there needs to be a additional hearing on this rescheduling. So those could be good cause reasons to reschedule it. It mirrors whatever it is that you wrote on your request to continue the hearing though. So make sure that you don't have two different reasons listed on one and then a different reason listed on here. And if this is the box that you do end up checking on the request to continue the hearing, then you should also make sure it's consistent. Or this is the first time that the restrained party has asked for more time to prepare, and the court reschedules the court date on its own motion. So the reason is the court doesn't have enough time to hear your case that day, and so therefore it's requesting you to come back. Now, serving or giving the order to the other party. So the request to reschedule was made by either the protected party, the restrained party, or the court. If it's the protected party, you, the one that's filing the restraining order, you do not have to serve the other party because they were there, their lawyer were there, and they were at the court date or agreed to reschedule the court date. You must have the restrained party personally served with a copy of this order and a copy of all documents listed on the form DV-109 by a certain date. And you can have this done with the sheriff's office because you probably have a new temporary restraining order, and all those documents still need to be not filed, but served on the other party. And so service requires personal service, and so you just include this document in addition to your restraining order packet. And then you must have the restrained party served with a copy of this order. This can be done by mail, and you must serve by a certain date. The court gives you the permission to serve the restraining party as listed on the attached form DV-117, and you could watch our other video about alternative methods of serving the other party, like publication, for example, or something else that the court wants you as the protected party to do in preparation of the upcoming hearing. Now, the restrained party, if they are the one that was requesting this rescheduling, then they do not have to serve you or the moving party because they or their lawyer were at the hearing, or they agreed to reschedule the court date. Or you must have the protected party personally served with a copy of this order by a certain date. You must have the protected party served with a copy of this order. This can be done by mail by a certain date, or something else that the court does want you to in fact do. And then the court can be the one to reschedule the hearing, and they can say that further notice is not required because both of you are there. Or the court will just mail a copy to all parties of the new court date, or something else that the court will in fact do, which will include service of this order on a request to continue hearing. There is no fee to serve, so the sheriff or marshal will serve this order for free. Bring all copies that need to be served to the sheriff, so make sure you do bring this form as well, along with your request for the Domestic Violence Restraining Order. And then any other orders that the court will make will write right here, so you do not fill that out. The judicial officer will sign it and date it. And then the instructions to the clerk is if the hearing is rescheduled and the court is extended, modified, or terminated a temporary restraining order, then the court must enter this into the CLETS or send this order to law enforcement to enter into CLETS. And if you don't know what CLETS is, we did a video on this previously, so please make sure you check that out. This must be done within 1 business day from the date that the order is made. And the clerk has to certify that this order is a true and correct copy of the original on file in the court, and he or she must date it, sign it, and have that seal. So it's very important to ensure that you leave your restraining order hearing that there is a signature here and there is a seal, so that the sheriffs can in fact serve this document on the other party. Well, we hope you found this helpful, and best of luck.